you because I've experienced so much of these type of situations and scenarios, and I want to share my experience and hopefully help you get through some future transactions with a little bit more knowledge on what needs to be done. The sales reps are going to be monitoring the chat room, so they're going to help me answer some of those questions. If you feel that your question needs a little bit more explanation, just pop on the chat room and let them know that you have a question and that you would like to pose your question to me, and I'm happy to stop and answer. We will have some Q&A at the end of the class. If you want to hold tight until then, I'm happy to do that as well. So I hope everybody enjoys this class, and so here we go. Let's see here. So death do us part. Of course, when you take a listing, it's pretty important that you know who the actual owners are, and the people that you are dealing with are indeed the owners. However, if you are dealing with people that inherited the property in one way or another because the owner actually has passed away, there's a lot of documentation that needs to be addressed. So if someone holds title to the property and they are deceased, it will often take time and documentation to make sure that the escrow closes and nothing comes back to haunt you from any beneficiaries or potential heirs. So in that case, there's people that have inherited the property, or they feel they inherited the property, but the paperwork has not been done properly, and so you're going to find yourself in a bit of a sticky situation. So before you go on that listing appointment, pull the current vesting deed. We are happy to help you with that. Customer service it's very simple for customer service to do that for you. So when you go meet that seller and their names don't match the deed that you have in your hand, then you can start asking them questions: why, who, what, when, where, and when did this all happen? And so that way it'll front load you with some questions and get you some answers. And then when you are ready to put that home on the market as a new listing, and in this market possibly get a buyer really, really quick, you'll be ready to go. So that's your number one most important step to get is a vesting deed, so you know what you're dealing with. Okay, Jen.
All right.
So where there's a will, there's a better way. So having said that, the title will not be able to use a copy of the will to allow you to sell the property. If the property is still held in the deceased's name and no other surviving people that are on title, the will is not going to allow you to sell the property because the will states that you are the person that's inheriting the property. However, the will is still important and very useful. You will use that will to acquire the correct documentation that title can use and act upon to be able to allow you to sell the inherited person to allow to sell the property. So where there's a will, there's a better way, but that will needs to be taken to the courts and prove to the courts that this is what the deceased wished for me to have the property, or whoever had the property, and they have the authority to do what they need to do with the property. So there's some definitions on the screen that kind of enlightens you to how you can use a will, and I love that. It gives you a blueprint, of how for the distribution of the estate. It just can't be used to sell the property. It can't be recorded to give you vesting of the property, but it can be used to be presented to the courts to start the process for that person to be able to sell the property. It is important to note that too soon, real quick.
I can
go over that real quick. It is important, it is important to note that the probate is still required even though there's a will, okay? So when you take that will to the courts, you're taking it to the courts to start the probate process. Now, Jennifer.
Now I can flip.
Yes. When it is straightforward, no probate required. This is our daily lives. It's easy. Life is easy. You take that grant deed to your listing appointment. Those names match. And then you find out how they hold title, whether they are husband and wife as joint tenants. If, for whatever reason, one of the spouses is deceased, no fear. You're still good to go. Title will just need a death certificate to deal with the deceased spouse's interest because they are held in joint tenancy. One spouse dies, and then they become the surviving joint tenant. And if that's who you're sitting in front of, you're good to go. So joint tenants is you're good to go, no fear. The next thing would be community property with right of survivorship. This is very, very, very similar to joint tenancy. It's just a community property has a little bit to do with tax basis and how they do their taxes, and that's a whole nother world, and that's something that we do not advise on. We send them to their CPA or whoever prepares their taxes to advise on whether they should hold title as community property or joint tenants or so on and so forth. But what the difference is community property with right of survivorship. If one of the spouses should pass away, you still do not need to go to probate. That's a very key word because people get very confused when they hear the words community property. They associate that with probate. But if it is followed with right of survivorship, it's the same thing as holding as joint tenants. We just need that death certificate, and we will do an affidavit of death of this vesting, as we would have done as affidavit of death of joint tenants on the vesting above. And then the last would be revocable transfer on death deed of record. This is going to be a little bit more sticky, if that's a word. The reason why is because we don't see them often, and title usually has a little bit of a challenge. I don't like to say the word problem because it's not a problem, because people have done this to protect, their real estate property, and it's just a different way to hold title, but it's something that if you find yourself in where you pulled the deed and that's what it is, give us a call, because we're going to have to get you in contact with title and see what can be done or if it's a doable situation. So we just mentioned this because you might come across it, and if you come across it, give us a call, okay? All right, next slide is there is also no probate for a trust. Trust, non-court way of distributing assets of a decedent, which are titled in the name of a trust. So we're going to go into the trust later on in the class, but this is important to just remind you that if the property is held in trust, you pull that grant deed, and the people you're meeting are the successor trustees of a trust where the original trustees are now deceased. You're not in bad shape. We just need additional documentation, which we will go over later on in the class. Okay? All right.
You want to answer a couple questions, Anna?
Yeah, I just noticed there was some chat activity, but I didn't get to see it here.
Okay, so Lisa Newfield was asking about the prelim, and she wanted to know if that was different than the vesting deed.
Yes, it is very different when you're pulling a prelim or just pulling a vesting deed. A vesting deed is just the last recorded deed that shows who actually owns the property. When you pull a prelim, you're pulling a prelim not only to be able to get a vesting, but it also comes with so much more information. If there's any liens, any defaulted taxes, if the taxes are current, it's super important too. I'll go on into it a little bit later, that if there is a lien on title, mainly a private deed of trust where the beneficiaries are deceased, that also can be problematic in your transaction. But we'll definitely go over that later in the classroom. If I remember right, when we were building the class, that we did address that. But it is different than asking for a prelim. And then there's another question, is that why it's best to be put in the trust? The trust allows you not to have to go through probate. So everybody has different situations. We don't really recommend one way or the other because everybody's situation is different. And so it's best that they either talk to their CPA or their family attorney to talk about their situation and find out what is best to either how to hold title or to put that property in trust. So I just encourage you to encourage your clients to really sit down with somebody that's what they do and go over their situation and put them in the best scenario as possible. So, okay, I hope that answered the question. Purpose of probate. Okay, a will is provided to be valid. So in order for it to be a seamless, smooth probate, if there is a will, that is your best case scenario because that will has been written out, signed, to all their wishes, the deceased wishes, and how they wanted their estate to be distributed. So that is your best case scenario, to provide a will to the courts so that they can go ahead and start the probate process and the proceedings and the hearings, and eventually your probate will end for the real property, and it'll basically be a mirror image of what the will has stated. If there is not a will, no fear. There's different steps that have to be taken within the probate process. When you go through the probate process, that you'll be guided on what needs to be presented, heirs would be contacted, and so on and so forth. So the administration of the personnel, real estate, property taxes, and debts of the estate. So that's what a will would outline. But if there's no will that exists, then you'll go a different route in the probate to determine how these personal real estate, property, and assets and debts of the estate will be handled and distributed, and then the court will decide on who and what and where and how it's going to be distributed. When I said that they have to contact heirs, the whole court is going to be asking, you know, who are the family members, who has any kind of say or stake into the estate that has to do with everything that they have, including their personal property and real estate property. Just a little touch on what I had talked about earlier, if a beneficiary on a piece of property, quote unquote, a deed of trust, and the beneficiary on the deed of trust is deceased, that would be something too, would be assets. That would be an asset for them, and that would have to also be determined. And then anybody that could possibly have an interest in the property would be contacted, and there's a process and there's a time frame where they are contacted, and that is tracked, and then there's a time limit, and if they haven't come forward, then their opportunity to have some kind of stake or claim into the estate has been extinguished. So the judicial determination of the character and status of the vesting, this is a red flag for title if the vesting is contested. So if they've gone through all of that and they've contacted the heirs, and we have an Aunt Sally that comes out of the woodwork from down south, and the property's here in Fresno, and Aunt Sally hasn't talked to anybody in 10, 15 years. However, she was contacted and she's come forward. That is a red flag, and so that might slow the process up a bit. But hopefully it'll get to the end result where the court has made a determination and has instructed on how Aunt Sally is going to be, her stake in the estate will be handled. So when we get that paperwork, that's already been resolved. But just to know that in that process, that may happen. You may go in thinking, oh, this is going to be a smooth probate. You know, my clients say there's only 2 brothers and this or that, and we're good to go. But just know that that is a possibility. Once all of that is taken care of and the process has been handled the way, you know, in its timeline, the final distribution of court order regarding the transfer of assets out of the decedent's estate would be issued. Let me make one little side note. Everybody's afraid of the word probate because they think like, oh my gosh, this is going to be tied up in probate for years. Not necessarily. If the probate can determine how the distribution of the real estate property can, you know, they can determine that part of the probate quickly, the court can order just the sale out of the probate to be dealt with, you know, in a certain time frame, and the probate can still be open and ongoing. So I don't want the word probate to scare you as a real estate agent, by no means, because probates do take a long time, depending on the size of the estate. But they can cut out the portion of the real estate estate and determine how that needs to be distributed, and the court can issue an order. And then that order comes to us, and then we record it as a transaction to put the vesting into the seller's client's name. So now going on to the actual probate, the simple term of a court procedure that directs distribution of assets of a decedent when there is a will or no will or trust. The duration is typically a year, depending on the size of the estate. So that's why I wanted to kind of mention that, you know, not to get too discouraged if you come across a situation where you're representing a seller that the property is in probate. It can be handled in less than a year, depending on any kind of heirs, contesting, you know, all those other situations that I had mentioned earlier. But just know that it's nothing to be afraid of, but it's something that has to be dealt with. So I mentioned that close. Just for the correct terms, property can be transferred during a probate, close as a probate sale. They must have court approval and go through a special process. And once the probate has ended, property can be using the court order documents as guidance. So having said this, if you are, I've seen this several times because I've had properties that have gone through probate. There is a probate sale purchase agreement in the car forms. I like it because it's very detailed. It addresses almost everything. So I do suggest that if you find yourself in the situation that you use that probate residential purchase agreement. Okay. Did I answer Lisa's question? Does the probate need to be completed prior? Yes, prior to the listing. No, not necessarily. Just know that if you list the property, you can list the property and it be in probate, but you may have to, and if they're the one, if the heirs are the ones that you are dealing with, are signing your listing agreement, and they're the ones that are processing the probate with the probate attorney, I think you'll be fine because they're the ones that are going to end up at the end result being your seller. Okay, so it doesn't have to be complete for you to be able to list the property. If something changes and the court finds that the heirs to be a different individual, then of course that listing agreement that has been signed by those potential heirs are no longer your client because the court has determined otherwise, if that makes a little bit of sense. So, and this is very, very good to mention that there is no such thing as a quick close on a property in probate, even with a cash buyer, because a lot of people have this misconception that they have a cash buyer, this can be taken care of right away. We don't have to deal with any lender or under title insurance, because they want to make sure that there's nobody that's going to come in and that's going to jeopardize their position as a lien holder, because it's a cash buyer. The cash buyer still needs to be insured on their own as an owner under their owner's policy, to make sure that they don't have any heirs knocking on their door saying, wait a minute, you know, I'm Aunt Sally and I was promised this property and I went away for 10 years and now I came back and I found out that it's sold. So no quick close if there is a cash buyer whatsoever. Okay? And thank you very much for confirming that there is a car RPA for probate. Again, like I told you, I love it. As an escrow officer, I can speak for, I want to say, probably all escrow officers around the most detailed purchase agreement that we get, and as fully completed that we get, and all the boxes are marked correctly, and there's no presumption, because we do not presume anything. We, as escrow holders, act upon instruction and instruction only. So when you provide your escrow officer a purchase agreement that's fully completed, all the correct boxes are marked according to the parties, what the parties have agreed to, you have just made your escrow officer's day. If you want to have a happy escrow officer, give him or her that completed, appropriate purchase agreement according to your transaction. So, okay, that was just a PSA. So, going to the California probate process. This is, I felt this was kind of a really good visual because you're going to have some sellers that are going to approach you that they want to sell, you know, Aunt Sally's home. She left it to me. I don't know what to do. It's a good visual that, you know, of course, they're going to end up having to go through the probate process, and this is your little roadmap to the probate process. You know, you file your petition for the probate, publish notice to the administrator, and then the hearing date on the probate, the petitions, letters issued, and then you prepare and file inventory. And what that is the inventory of their estate, not inventory of what the home has inside of the property. No reason why I mention it, you know, because it has come up in a transaction where I've had an escrow that was in probate, you know, and this was coming up, and they were calling me because they couldn't get a hold, you know, of they were trying to do the probate themselves. Unfortunately, I'm not able to act upon because I'm not licensed as an attorney, but this is kind of gets confusing for people, because believe it or not, there's a lot of people that want and are adamant on doing the probate themselves because they don't want to invest into a probate attorney to handle this for them. And I want to warn you, if you find yourself with a client that way, the process will be a lot longer, because if they do one thing wrong and then they go to their hearing, or they didn't do their notice correctly and they have to send out new notices, what does that do? It delays the process, which will delay your transaction. So if you find yourself with a client that insists on doing the process, because it can be done by themselves. You don't necessarily need to have a probate attorney. It will take a lot longer than what we are letting you know, the estimated time that it's going to take. Give notice to the known creditors, accept and or reject claims. So at this point, if the estate owned any unrecorded loans, this gives them the opportunity to make their stake on the estate. And then prepare the final accounting, send notice of final accounting out, and then the court sets a hearing on the final accounting, and then the distribution of assets pursuant to the court order, and then the final discharge. At some point, when we had talked about the property, if a property can be sold in the middle of a probate, it can, and in the middle of this process, they would issue an order just for the sale. because this process is just basically for the entire estate. Okay. All right. So this is a very good visual as well. It's similar to what I just went over with you, but I like this one because it not only gives you the process, but it gives you a time frame. So this is a nice little good visual for your clients to know, you know, the roadmap, not only what they're going to be having to go through, but what kind of time frame is they're up against. And it gives them some realistic expectations. And I think that's super, super important in our industry is realistic expectations, especially now in the time that we are. That everybody hears the word COVID all day, every day. It's just what our world is right now. And I think it's very, very important that the client not only understands the realistic expectations of a probate, but the realistic expectations of a probate in COVID. So not to say it's going to be extended that much longer than what we're, this diagram has been a diagram that we've used for quite some time, and it's pretty right on. It's known to be truthful as far as the time frames. But like I said, we're living in a different time right now. We're going to find ourselves back to a different normal, but maybe the normal that we know of. But I just think it's important that you share, you know, this with your clients to let them know that this is what they're looking for or looking at. Okay, so I think I went through all of that, but this just gives you a visual of the time frame, time limits, or time that it's going to take to do those processes.
Anna, we have a question of when adult children are listed as the beneficiaries on title and both parents pass, do they need to go through probate?
So the only way that would be a time where probate is not necessarily, when you say the adult children as beneficiaries on title, they wouldn't typically be listed as beneficiaries on title. They would be listed as title holders. They would be part of the vesting. So, for example, Ryan and Anna Gettman, husband and wife, and Nathan and Nathan Gettman, a single man, Nicholas Gettman, a single man, all as joint tenants, for example. And my husband and I passed away. So in that case, Nicholas and Nathan Gettman will acquire our portion of the joint tenancy without going to probate. So you don't necessarily have a way of listing adult children as beneficiaries on title, with the exception of a trust. You are listing, if the property is in a trust, those adult children would be in that trust, if that's how it was set up, as beneficiaries. And they wouldn't technically come up on title as beneficiary, but the fact that the property is held in a trust and they are, quote unquote, whether they're successor trustees or not, that's not an issue. They would be the beneficiaries of that trust, and that property belongs in that trust, and then that trust would be distributed accordingly, and if they were beneficiaries in that trust. So you can't list adult children as beneficiaries on title, but they can hold title as long as they're over 18 and be on title, and depending on how the vesting is, if it's joint tenants, then there's no probate. If they are listed as an undivided 1/4 interest, and Ryan Gettman was 1/4 interest, and Anna Gettman was 1/4 interest, and the two boys were 1/4 interest, and Anna and Ryan passed away, their 50% will go to probate, and the other 50% stay on title, and the 50% of that property, of that vested property, will go to probate. I hope that makes sense. Okay. Oh, this is a great segue. Who gets the money in a probate sale? So, well, going back to all of that, visual, at the very end, it states that there's a final distribution or a court order, and it is important to say that there's other documents that get issued through the court, whether it's a final distribution or letters of administration, or letters of testamentary. Those are just a few documents that the courts can issue in a probate, depending on the value of the property or the value of the estate. So in those documents will state how the escrow holder is to distribute the proceeds. So it will clearly line out, say there's two heirs, and it'll say, you know, Anna Gettman, in the sale of the property located at XYZ shall receive 50% of the proceeds, and Anna Gettman, at the close of escrow of XYZ shall receive 25% of the proceeds. And so the final distribution will definitely line out who is to be paid and what. If there were certain debts that were entered into the probate that the heirs felt that needed to be taken care of, and they necessarily didn't want to use any proceeds, they can petition the court for certain debt to be taken care of. And I've seen final distributions where they've instructed us to pay certain creditors through the close of escrow. So the courts will determine on who gets the proceeds of the sale and how. If there's letters of testamentary or letters of administration, the proceeds would be issued to Anna Gettman, the administrator of the estate of, and that those proceeds will be written in that manner, and then they would be, you'd probably go back, and when that happens, that is because they were trying to cut out the sale of the property out of the probate to be able to handle it a little bit quicker. And so they still haven't determined how the proceeds were to be distributed. So they will issue those type of letters, and then that money would be payable to Anna Gettman, the administrator of the estate of whoever, and those funds would go into that estate account, and then they would determine at another time on distributing. So that goes back to, you don't need a probate to be completely done to be able to sell a property. Let's see here, that will be responsible for the correct distribution. Okay, if the estate has cleared probate, the funds will be distributed directly to the new vested owners. Yes, and I've done that too. Like I said, I've handled these quite often where I've had to the estate, to a trust, not because I know I don't want to confuse you, but probate has instructed me to distribute proceeds to, a surviving trustee of a trust, because there was maybe at that instant there was a minor that they wanted to make sure that they got their inheritance. And then there's straight order distribution. 100% proceeds are to be distributed to Anna Gettman at the close of escrow, and Anna Gettman is now the owner of the property. I just closed an escrow 2-3 days ago where it was a final distribution, and there was the 3 sisters, and it clearly states, each sister is to get 33.33% of the sale, and so it was very clear. So yes, they can go directly, the proceeds can go directly to the individual that is legally the owner of the property after the probate. Again, there is no such thing as a quick close on a property in a probate, even with a cash buyer. I just want to, we just think it's so important to say that, only because everything's easier and quicker with a cash buyer, isn't it? So, there's always a caveat. Trust. Simply the process. The trust spells out exactly what happens upon the death of the trustee of the trust. So going back to what I had said earlier, that if we have Ryan and Anna Gettman, trustees of the Gettman Family Trust, and our property is in the trust, and you take that vesting deed to your listing appointment, and Anna and Ryan Gettman are the ones sitting in front of you, smooth sailing. We are just going to need a copy of the first few pages of the trust and a trust certification, which we happily draw this trust certification up to be signed with our escrow documents. So that's one thing that you don't have to worry about. But we'll explain that to the sellers exactly what we're needing. So when the property is in a trust and the trustee, original or successor, must be your seller, can't be anybody else. If the person is deceased, we will need a copy of the trust, just like I stated, to confirm the correct party is selling. Sellers, whether they're the original trustees or the successor trustees, they get really finicky, and they get really, some get agitated, so they get really uncomfortable when the title company is asking them for a copy of their trust. And they have every right to be uncomfortable. They have every reason to be uncomfortable, because in trust, it talks about everything and anything of their assets and what and who and when. We don't want a full copy of their trust. Honestly, anything other than who the trustees are or who the successor trustees are, anything other than that is none of our business, and we don't want it. They get really antsy when we ask. I try to ask just for the first, few pages, but they must clearly outline who the trustees are, the exact name of the trust, and if we're dealing with deceased trustees, who are the successor trustees. We may go back in some instances and ask for a few more pages, because we've had instances where the trustees are deceased and the successor trustees, we may have 2 or 3, and that third one or the second one just doesn't want anything to do with anything of selling any kind of property. And sometimes a few more pages down the trust talks about should, a successor trustee fail to act, they'll name somebody else. So there are oftentimes, we'll ask for just a few pages of the beginning of the trust, and we should be good. But if we're dealing with a trustee that just doesn't want to do anything with anything, number one, we have to find out if there's somebody replacing that person. And if there's not, they officially have to resign as a trustee. And that the family attorney would have to draw up a resignation of trustee and would have to be signed by that trustee and notarized. So going back to my original point, having said that we are going to ask for that, just reassure your clients that we don't want the whole thing. We don't need the whole thing. It's none of our business. We're not trying to see everything else. We're just trying to determine who our parties are that have the right to sign and to sell. If they are deceased, any of the original trustees or just one, if we have 2 trustees and only one, we will need a death certificate, because we will, if it hasn't been done already by the family attorney, we will have to draw up an affidavit of death of trustee or an affidavit of change of trustee, and a death certificate does have to accompany that. It's super important that you provide the death certificate as soon as possible, because the affidavit does reference not only the trust, but it references the death certificate. So that is true to be the same for what I had mentioned earlier about a joint tenant passing away and having a surviving joint tenant. That would be true for that too. To provide the death certificate as soon as possible so we can drop that document appropriately. Just a little tidbit. You can scan the escrow officer a copy of the death certificate to be able to allow him or her to draw that document, but know that they will need a certified copy of the death certificate before closing, so they can attach the certified copy to the affidavit of death of trustee to be recorded, because we have to have that to be able to record that document, because that document will not be sufficient for the recorder, and they will kick it out. We cannot, as a title and escrow company, because we are bound by affirming that everything that we are scanning to the recorder's portal is original documents and certified documents. Yeah, so just because you scan a copy of that death certificate to the escrow officer, he or she cannot use a scanned copy. It has to be a certified copy. When I talk to sellers, I like to let them know it's a colorful kind of textured paper that you receive, because a lot of people think that that's their original, and it's not an original. It's a certified copy of the original that is kept in the county hall of records, because they actually keep the original, and they just issued the certified copy, and it's the nice, pretty pink and blue textured paper. I just something to mention. I don't want to like open up a whole nother can of worms, but it's becoming more difficult for title and escrow companies to assist on those requests for certified copies. A couple of years ago, we used to be able to order the certified copies of the death certificates, just so we can, you know, expedite the process, or maybe the surviving spouse or the surviving trustee just exhausted all of their certified copies. It's getting to the point where now we can't even order those for the sellers, and so it's best that you have that conversation, that if they are running low or they have only one, to try to jump on the fact that they should probably order more, because we are going to have that for a few weeks, and if they need it, we can't hand it back to them, because we need it to be able to record. So just for that. Did I cover? We will prepare this area. Yeah, okay. Any questions? I want to make sure am I missing any questions so far? No. Okay. Well, you guys are really, really knowledgeable, or I'm really, really good, but I'm hoping that I'm addressing any questions that you guys may have. So, okay. Who gets the money when the property is in a trust? The proceeds will be 100% of the time be issued to the trust. But however, I want to be clear. They will be issued, for example, to Ryan Gettman and Anna Gettman, trustees of the Gettman Family Trust. They would never be issued just to the Gettman Family Trust. And I'm going to kind of throw in a side note on that in just a minute. We are not able to issue proceeds. If the property is held into a trust, we are not able to issue just solely to Anna and Ryan Gettman's name. It will always be Ryan Gettman and Anna Gettman, trustees of the Gettman Family Trust, because that is who the owner is. If Anna Gettman owned a property by herself and we closed, we wouldn't issue proceeds to a Jennifer Shepherd. You know, we wouldn't do that. So it holds the same to, sorry Jennifer, I love you, but you can't have my money. But it holds the same as a trust. So we would issue the proceeds in the trustee's name of the trust. Before I move on to the rest of the proceeds and how it's being issued, if a property if you pull that deed and the property just says the Gettman Family Trust, that deed is erroneous and it was recorded erroneously. Believe it or not, people go and record their own deeds by themselves and don't call anybody, don't ask anybody, don't consult a real estate attorney or anything. They just say, oh, I want the property in my trust, I'm going to go record this deed. A trust is an entity, and unlike a corporation or LLC, it can't hold title by itself. It has to be trustees of the trust. So just a side note. Going back to the issuing of the proceeds in a trust, if you are dealing with successor trustees or children of original trusts, and it's been a while and there's no bank account in the trust name, you're going to have a problem. because we are not, again, allowed to not issue proceeds in that trust, outside of that trust name, you're going to have a check or a wire in cyberspace just kind of sitting there and then eventually getting ready to reject it back to us. The banks require a bank account to be opened in the trust name. So there's no way Anna Gettman and Ryan Gettman can take that check that's written to Anna Gettman and Ryan Gettman, trustees of the Gettman Family Trust, and take it to their bank and just put it in their individual account. The bank's going to say, whoa, 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 no, you can't do this. So it's very, 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 very important that the trustees of the trust have a bank account established, ready to go by the time your escrow closes. Because if a check is issued or a wire is sent, and there's no bank account that exists with that trust name, they will not deposit that check, and that bank will reject that wire back to us. And so, and then we wouldn't have a choice. We would have no choice but to issue a check, because we as escrow holders, we can't hold on. We're not a bank, so we can't hold on to their money until they decide what to do with it. So, I hope that's clear. And yeah, okay. Thank you. What if the property is held by a corporation? A dead member of the corporation has to be dealt with. An amendment to their articles or bylaws or in a resolution supported by a meeting of the members or board members. I recently had one where a corporation is on title. This particular one, they delivered their corporate docs to me, so I know who signs for the corporation. And through a few phone calls, I had learned that one of the signers that typically signed for the corporation had passed away 6 months prior. So that does have to be dealt with. When there is a signer that is no longer with us, the corporation has to decide whether they're going to leave it just with the one signer that is currently on there, or they're going to substitute or add or so, and then there has to be a corporate resolution supporting that, of who the signer is. And a corporate resolution is just a single document that is typed up by the secretary of the corporation at the end of a meeting that the corporation has held to determine what's going to happen with the deceased signing position. So it's good to find out too as well, if you're representing a corporation, that who the signers are. So when you get that vesting deed and you go to your listing appointment and you see that it's a corporate, it's good to ask who are your, because you're going to need to know anyways on who's going to sign your listing agreement and all the disclosures. So it's best to maybe ask for, once they tell you who the signers are, just ask for a copy of those articles and or bylaws, just to support the fact that they are indeed the people that are signing for the corporation. Okay. All right, let's see here. What makes things more complicated? This is my favorite slide. Reason being is I've had some fun situations when no one tells us that the seller is dead. And you're kind of sitting there thinking like, really? And I'm like, yeah, it happens. And so we've gotten to where we're a couple weeks into the transaction and we are reaching out to the seller and we're saying, hey, Tom Smith, I need to make an appointment for you to sign your escrow documents. You know, when are you available? And make sure you have a valid ID that matches, you know, your name on who we have on title. We just want to verify. And they said, okay, well, I'm not on title, and my dad, Tom Smith Sr., is the one that's on title. And I'm like, oh, okay, well, are you, okay, so we're facilitating the signing through you, and no, that's my dad's dead. And we're like, uh-oh, wait, what? They have the same name. One's a senior, one's a junior. It's happened, guys. It's happened, and we're like, whoa. So I know that you have a ton of stuff to go through on your listing appointments, or, you know, where you're signing your listing agreements. Just ask you know, anybody on title has passed away? I know it's a tough question to ask. If you know, tell your escrow officer right away. So it's a good thing to do. If an affidavit of death has not been recorded, a preliminary title report will not reveal this. So they have had I've had instances where they've done affidavits of death and they just kind of held on to it and never thought that they needed to record it. We didn't pick it up because it was never recorded, but, you know, so on and so forth. There's plenty of, I can give you a lot of stories where we find out that there's a dead person involved some way, somehow, somewhere, throughout any kind of transaction, whether it's a beneficiary of a recorded deed of trust or an actual owner. And talking about the missing beneficiaries on an unpaid deed of trust. So same thing. We have a deed of trust, a private money deed of trust that is on record, and we contact the seller and we say, okay, we're just reaching out to you because we need to get some payoff information. We see a first and a second, or we see a first, whatever the case may be, and one of the deeds of trust is a private beneficiary, a private note, and they tell us, oh, well, that person has passed away, and I actually paid them off before they passed away, so we're good. No, we're not good. So we have to go through the whole situation as far as, you know, errors, if there's any children that are aware of that, and that too would have to go through the probate process if the beneficiary isn't named the trust. If the beneficiary is named the trust, we just need to locate the successor trustees, get either a zero demand and a substitution of trustee in full reconveyance, and we'll draw those up and we're good to go. But if the beneficiary is deceased and there's no errors that the owner has no idea who, what, when, where, how, you're definitely going to have to go through some kind of probate process with that. If it could, there is such a thing, and it all depends on the situation. If it's a corporate beneficiary and there's some, you know, you were dealing with one of the corporate officers and that person has passed away, there may or may not be a way, but it could be a situation where you could go and get the deed of trust bonded, you know, go to an insurance company and apply for a bond. But most times, you're probably going to have to go through the probate process of trying to locate that benefit, the heirs of the deceased beneficiary. I have one right now. It's not a deed of trust. It's actually a abstracted judgment, and the original person, it's been re-recorded to survive because it's been re-recorded by their son. So I was able to find them, but you can't get away. You can't, even when they're dead, you still owe their money, one way or the other. So, any questions? Okay, we're so good. Let's see, death during escrow. I've had this one time in 23 years. And I'm kind of glad because it's kind of like not a fun, it's kind of a sad situation. But if the seller dies prior to the close of escrow, we can proceed to close if they have signed the deed. So if they've already signed all of their escrow documents and that deed has already been signed and notarized, prior to their passing, we can still close escrow because nothing has changed. Their intention was to sell the property before they passed away. So we're good. If a buyer dies prior to the close of escrow, we will usually cancel the escrow unless the surviving party wants to and is qualified to proceed. And it goes back to, the surviving party as husband and wife as joint tenants. I'm a firm believer of putting things out in the universe, so I'm not going to even put people's names in that situation, but husband passes away and wife is a surviving joint tenant. And if she chooses to still continue with the process and of purchasing the property, we are able to go ahead and proceed with the sale. If both parties pass away, of course, there's no escrow, because they can't, for the lack of better words, exercise and negotiate that contract. So hopefully you don't find yourself in that situation, because like I said, it's happened once, and it's a tough situation. You kind of just, you know, really don't want to be in it. So
we have a question. What if the probate is in process and they die, but they sign the deed before probate has made it to final court date?
There wouldn't be a probate if, I'm a little bit confused with that question, because the only way you'll go to probate is if the owner of the property, and there was only, you know, owners of the property has passed away, or owner of the property has passed away, and there was no joint tenancy or any survivor of the joint tenancy. So because there really wouldn't be a deed.
So that was Sarah Douglas. If she'd like to, Sarah, if you want to unmute and clarify if we're not answering your question the way that you thought. And at this time we are right at 10:30, so we will open it up to other questions that people may have.
The wife,
go ahead.
can you hear, real quickly to clarify, the wife is ill. Her husband passed away a few years ago. Probate is scheduled for November 9th. And so she doesn't have, we don't have confirmation yet, but should we go ahead and have her sign the deed?
The deed will be invalid because the court hasn't decided. So the date of the deed being notarized, because it's a different situation when I was saying that if the seller has signed the deed, we can still close. That's a non-probate transaction. Because if she signs a deed, it's a presumptuous deed, because the court hasn't officially ordered that she's the owner of that property and has the right to sell. Because your court order is going to be dated after the deed is signed and notarized, and that timing doesn't jive. Does that make sense?
Yes, it does, and that's why our escrow officer advised us not to sign. Thank you.
You're welcome. Okay.
So Lisa asked us to go back to the last slide. Lisa, did you have a question?
I'm trying to do two things here. So, yeah, I wanted the last slide because I wanted to write down that last piece. But so as a realtor, I mean, as we learned about contracts and everything, we were told that those contracts, once those are signed, technically the sale is supposed to continue even if somebody passes away.
If the deed is, are you talking about just a normal residential contract?
Yeah.
If they haven't signed that deed, it becomes problematic. The deed has to be.
Oh, wait, go back to that slide. I almost. Okay, thank you. I'm trying to take care of that. And okay, well. So anyway, don't lose that slide yet. But yeah. So then it would just be a legal matter. Then that's something that legal would handle.
Yeah, you are right. If they sign that contract, the intention to sell is still there. They passed away, but they haven't executed the legal document to transfer title, which is that grant deed. If they haven't executed it, then that becomes a problem, and then it shoots into probate.
Yeah, we'll have to put everything on pause.
Mm-hmm.
All right, well, I know we're a little bit over our time, so we understand if people start to drop off, but are there any other questions?
Okay, I'm done with that last slide. Thank you.
This is Anna's information. If you need to get a hold of her for any reason, she will be happy to answer your questions. If there's another Chicago title escrow officer that you work with regularly, Most of our escrow officers do have experience in this area, but for some reason, Anna has kind of gotten to be an expert in this area just by being willing to do the research and be very knowledgeable in this arena. So thank you, Anna, so much for teaching our class today. And it looks like we successfully recorded. So we will just go ahead and send that out to everybody along with the resource packet that I mentioned. And hope everybody has a fantastic day and weekend. Anna, any closing thoughts?
Nothing. I just thank you very much for putting yourself in the position to get educated and empower yourself. I truly, truly believe that the education is best, even in our industry. And I'm excited for each and every one of you because now you know what to do.
All
Thank
right.
you. Thank you very much. I have a question really quick. So this is a great class that we just had, or some information we had, because I had a couple of issues similar to these, so it's well needed. But just thinking ahead, have you thought about somebody that has an expertise in foreclosures?